definitely out of the sheriff's office. I need to read you something, okay?
I think I need to say anything, do I?
Do you wish to speak to me?
No, I was just trying to survive. Believe it or not, I do feel bad for what I did.
This analysis focuses entirely on the law, the constitutional doctrine, and the strategic choices that shape the outcome of this case. The center of gravity here is not search or force, but the Fifth Amendment privilege against compelled self-incrimination.
Sorry.
Tell me what happened.
Okay. So, I all on this flash drive will have video of the incidents. I identified the thefts last week, and as I was reviewing to see how far back it went, I have all the way until February 1st until April 22nd.
So it's a collective from not just today. It's collective.
Correct.
Of how long?
From February 1st through April 22nd. It's all on here.
April what?
April 22nd.
April what? 22nd?
Yes.
This year?
Correct.
All right. So what happened today?
So today I had a conversation with her where she admitted to doing what I have already on here. But she also
She's an employee?
correct.
Okay.
And what she would do is she would bring merchandise from the sales floor that she intends to purchase, brings them over to our self-checkout registers. And instead of ringing up all the items, she would only ring up some of the items.
Okay.
The others, she would still keep in the bag and place in shopping cart. And then at the end of her shift, that she would do this probably within 15 to 30 minutes of her shift ending. She would be with all of the items.
Okay. Do you have a receipt for all those items?
Yes.
Okay. All the items that she didn't scan?
All on here is this right here, what you're seeing here. So
you put in all the items that was not scanned
correct.
on there, on the flash drive?
Correct. So each folder is a date. These, and again, all of this is in this flash drive.
Okay. On there though, right?
This is these are the items that were paid for.
And what wasn't paid for?
These are the items that were not paid for. We've indicated which date and transaction that it corresponds to.
Okay.
So
Okay, so was that finally today or was that after?
And then this is just an Excel spreadsheet of each one, including the loss.
The loss of each
Correct.
of each
The ones that are blank is either she did pay for all of it, or it doesn't correspond to a law.
Okay.
And
so how did you catch her today?
In Miranda versus Arizona, decided in 1966, the Supreme Court held that custodial interrogation requires a clear warning of rights. Statements taken without that warning, or without a valid waiver, cannot be used against a defendant at trial. A valid waiver must be knowing, intelligent, and voluntary, and the burden of proving it rests on the prosecution. The advisement delivered here was complete, covering silence, counsel of choice, appointed counsel for the indigent, and the absence of threats or promises. Procedurally, that warning is close to a model example, and it satisfies the threshold Miranda demands.
that's the problem. Well, today she came into work and I had a conversation
Okay, where is she at now?
in the office.
Okay.
No.
All right, so I'm definitely out of the sheriff's office. I need to read you something, okay? I'm required to warn you before you make any statement that you have fallen constitutional rights. You have the right to remain silent, not answering my questions. Any statement must be and freely, voluntarily given. You have the right to the preservation of a lawyer of your choice before you make any statement and during any questioning. If you cannot afford a lawyer, you're entitled to the preservation of a court-appointed lawyer before you make any statement during any questioning. If at any time during the interview you do not wish to answer any questions, you are privileged to remain silent. I can make no threats or promises to induce you to make a statement. This will be of your own free will. Any statement can and will be used against you in the court of law. With these following rights in mind, do you wish to speak to me?
I think I need to say anything, do I?
No, I mean, I have to look at him. I mean, with the following rights I just read, you understand all the rights you just read.
Yes.
So, with these rights in mind, do you wish to speak to me?
No, and not that's going to be held against me, no.
Okay, so you don't want to speak to me.
Well, what am I supposed to say? I mean,
I can't tell you exactly what to say. It's just something that'll probably defend yourself. I don't know. I can't tell you what to say. It just I'm in reference to why I'm here. If you want to speak to me further about the reason why I'm here.
I can just all I can say is I'm sorry, and I wasn't meaning to hurt anybody. I wasn't trying to do anything. You know, I was just trying to survive. You know, and I'm willing to pay back everything. You know, that I will do. I mean, 'cause believe it or not, I do feel bad for what I did.
Was that statement to him or to me?
Well, I'm just making the statement in general.
So it's your.
I just got my back against the wall.
I'm understand. Okay. So you're telling me you're making a statement to him, but it's just an outward statement. It's not direct to anyone.
Well, I already talked to him. I done said that I would pay it back. I just don't know what else to say or do. I'm scared to death right now.
Oh, okay, I understand that. So
I am. I'm scared to death.
all right. So speaking to me, yes or no? Because I can take into consideration you didn't give it's utterance. It's not you spontaneously uttered something. I just need like a yes. I want to talk to you. No, I'm not. I need something.
I mean, yeah, I'll talk to you about I just don't know what to tell you.
Okay.
I mean, I've already went through the motions of everything.
Okay.
Under Bergwis versus Tompkins from 2010, a suspect must invoke the right to silence clearly and without ambiguity. A direct refusal to speak meets that standard and triggers the protections that follow. Michigan versus Mosley, decided in 1975, requires that an invocation of silence be scrupulously honored. In practice, that means express questioning must stop once the right has been asserted. The analysis then turns on Rhode Island versus Innis, decided in 1980, which defines interrogation precisely. Interrogation is express questioning or its functional equivalent, meaning words or conduct likely to draw out an incriminating response. That same decision reaffirms that statements a person volunteers freely are never barred by the Fifth Amendment. This is the legal hinge of the case. A subject who invokes the right and then keeps speaking has volunteered, and those statements remain admissible. When questioning later resumes, the doctrine asks whether the subject reinitiated and knowingly waived the right just asserted. That sequence creates a genuine suppression risk, and it is exactly the record a defense motion is built upon. The counterargument is voluntary waiver, and reasonable judges could resolve that question either way. Had the right to counsel been invoked instead, Edwards versus Arizona would bar all questioning until counsel was present.
Is there a reason for such a vast quantity of thefts?
6 Bravo 248 Temple.
6 Bravo 224.
Why is it such a vast amount?
Yeah, like what is it's a lot. It's over 2 months, 3 months, the time frame?
What, from November till now?
For November?
I guess that's what he told me.
So it's prior.
I'm going by what he's telling me. What is going on? He told me November, so I'm like November, December, January, February, March, April.
Wait outside so I can talk to him. So all right, can you two them?
Sorry.
Can you wait outside?
Yeah.
I need a chair. All right. Just give me a submit fee, okay?
No problem.
Okay. All right. So, are you saying you've been doing this since November?
Well, I'm just going by. I don't know.
It's not on what Slender's is telling me. It's what you want to tell me. If you're telling me it's been November,
well,
okay.
I'm going by what he said. He said since November. I don't know when. I don't know. I really don't know when I actually started.
You don't know when you actually started.
Right. So, just,
Okay.
So
Yeah.
November is when I guess is when I started it.
Of 2023.
Yeah.
Okay. Is there a reason for you doing this?
I've had a rough couple of years, and my husband died, my mom died, my son died. I'm losing my house. I lost my management role. Was making way less money than what I was used to, and I had, I just didn't feel like I had a choice. I mean, I didn't know what else to do. I mean, I'm alone down here pretty much. And I didn't know what else to do.
So you resorted to it in the sense that what were you stealing?
Well, food for me,
Food?
Some food.
Just to survive in a sense?
Yeah, in a sense, and then, I did steal some cat food because, I have a couple
Yeah, your
cats,
cats.
but...
I understand, because you don't want your cats to be dying in the house and you're trying to survive yourself. I understand.
And I don't know what else to do with that, you know what I mean? I just didn't know what else to do. I really didn't know what else to do.
Okay. All right, so from what I'm understanding is you're telling me that you resorted to a crime of stealing food for yourself to survive and for your cats to survive at your house. You have no help in Florida. It's just you down here after your husband died and you have death in the family.
I have my daughter, but she's got her own 3 kids and stuff like that. I can't.
Where's your daughter at?
She lives up there on Forest Hill.
Forest Hill.
I can't.
She's not able to at least provide you with any kind of $50 or some groceries, nothing like that.
She's helped me out a little bit here and there, but she's got bills to pay too, and she got, like I said, she just had a baby, and she's got 3 kids of her own, that she's got to take care of, and I don't want to take money out of her pocket and deprive her the kids. You know what I mean? I don't want that to happen.
Okay.
So it was like a vicious circle. I didn't know
what to do, what the way to get out.
I didn't know what to do.
Okay.
I just really didn't. I mean, I feel bad for what I did. And if I probably wouldn't have done it. I wouldn't do it over again. That's for sure. But
have you seeked any help from the county?
They tell me I make too much money because I try to get on food stamps. I try to get.
No, I'm talking about not just food stamps. Food stamps is a government level. I'm talking about like through the county where there can be food bank. You can get your food, get you ready with stuff. There's various.
I don't have a car to get anywhere.
That's fine. They'll be able to bring it to you. They just tell them your circumstances. They will help you. They don't want. This is such the homelessness in Palm Beach County is so large. They don't want to add to that. So they're gonna obviously get the help to people they can help.
I just didn't know where to get the help. I didn't know how to go find out about help. I didn't know.
Okay.
I've never done this before.
Okay.
I never. This recently started happening. I've never done it in the past. Didn't have need to.
Yeah.
I just.
I understand. Trust me, I understand you. Sometimes you have to do what you have to do in order to.
I'm 58 years old and I have nobody, more or less. You know what I mean? I mean, everybody that was down here with me has died. My husband died of cancer. My mom died of a heart attack. And I got a house that I can't pay for. It's going into foreclosure. And I don't even know when I'm going to have to be out of my house.
No, until it goes into foreclosure.
It's already in foreclosure. It was supposed to go up for auction last Tuesday. And I guess something happened and the auction, took place, but the guy that was buying it, I guess, couldn't come up with the rest of the money, so he defaulted on that.
Okay.
So, I don't know if and when I'm going to have to get out of my house. They didn't come knock on my door and tell me to get out. I don't know. I'm just scared. I'm really, really scared.
Okay.
I'm 58 years old and I'm just trying to make it. That's all.
Yeah, life is hard.
And I am really sorry that I did
Everything's
it.
tough right now.
Everything.
I mean, I don't know.
No problem.
Yeah,
but get your call.
I guess I'm going to jail.
We don't know yet. Likely, yeah. But we'll see.
I really don't want to go to jail. I mean,
I understand, but um, there's like laws of this. I get what you're saying, but we're working all of that. Have you heard about the food bank at Boynton in Hampton area?
no, I've never.
Yeah, there's a church over there that gives out food.
The Fourth Amendment plays only a minor role because the documentary evidence was assembled by a private party. Under United States versus Jacobson from 1984, a private search conducted without government direction falls outside Fourth Amendment protection. On the substantive offense, Florida Statute Section 812.014 controls the charge. Theft of $750 or more, but less than $20,000, is grand theft of the third degree. That is a third-degree felony, punishable by up to 5 years of imprisonment, 5 years of probation, and a $5,000 fine. Florida law also permits aggregation, combining thefts committed under a single scheme into one charge valued in total. This is how a series of minor, individually misdemeanor incidents becomes a single felony exposure. Personal hardship does not alter the elements of the offense, but a court weighs it heavily at sentencing. Remorse and an offer of restitution can support a non-custodial sentence, consistent with the probationary outcome reached here.
Oh, it doesn't work? What? Because it's...
This one doesn't open this way. Can I smoke a cigarette?
Sure.
I am gonna go to jail.
Awesome, dude.
Who's it up to?
Huh?
Who's it up to?
State of Florida, we're just trying to verify what we can do in reference to this. So understand that you were stealing for food, but the quantity is felony. So...
Turning to the grades, the investigating deputy earns a B+. The advisement was thorough, and the recognition of the volunteered statement doctrine was sophisticated. The deduction reflects substantive questioning that resumed after a clear invocation, introducing avoidable legal risk. The subject receives a B-, measured by legal decision-making rather than by sympathy. Cooperation and composure were assets, but invoking the right and then confessing surrendered a decisive advantage. The agency earns a B+, reflecting sound training tempered by the same concern about questioning after invocation. Now the lesson, stated briefly. A constitutional right protects only the person who actually exercises it. Invoking the right to silence and then abandoning it can leave a person worse off than never speaking at all. For officers, an invocation must be honored cleanly, because a volunteered statement and a continued interrogation are separated by a thin, heavily litigated line. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.